Hello everyone, it's been a long time since I've uploaded a video. Today we'll be discussing about Talaq as well as Faskh. Before I explain about Talaq-e-Ahsan, Hasan, Biddat as well as Talaq-e-Tafwiz, there are few basic concepts that you should understand. Those are Tuhur as well as Iddat. So Iddat is the period which signifies the period between the menstrual cycles, and it can signify a period of mourning, and it can also signify a period for reconcilability between the couples. And Tuhur meant period of purity. So for example, if there is a person called as Fatima, and let us suppose her husband wants to give her divorce. So how will he do it? So let us suppose today she gets periods. So today the word talaq cannot be uttered. So it should be uttered only after 7 days or a lapse of 8 days, and after the menstrual cycle gets over. So 8 days after now, the first word, that is talaq, should be uttered. See, talaq under the Talaq-e-Hasan is used only once, okay, and not thrice. Talaq-e-Hasan is where the word talaq is used during the second iddat period, third iddat period, like that. But under Talaq-e-Hasan, it is only once that the word talaq is utilized. So you have to understand that under the Muslim law, especially during the prophetic era, talaq was considered to be the most detestable thing, and it should be something which a man would give to the wife as a last resort. And if I have to tell you, Prophet Muhammad actually told that a man had to give divorce or talaq only if he was unable to perform marital obligation or he suffered from impotency. But today, see, talaq has become a unilateral act in the hands of the husband. And today we know Talaq-e-Ahsan, Hasan, and Talaq-e-Biddat as the forms in which talaq is given by the husband to the wives. Talaq-e-Biddat was struck down as unconstitutional under the Shaira Bano versus Union of India case. I'll be discussing about those cases in the subsequent slides, and I will be discussing about each form of talaq. So until then, you have to pay attention, and I'll move on to the next part of the lecture. Let us now discuss the various talaqs under the Muslim law. The first one is Talaq-e-Ahsan, and the next one is Talaq-e-Hasan. The third one is Talaq-e-Biddat. So Talaq-e-Ahsan is the most approved, Talaq-e-Hasan is approved, and the Talaq-e-Biddat is considered to be disapproved. If you have to remember Talaq-e-Ahsan and Hasan, you can remember it this way. Imagine that you are eating an apple. So let us suppose you have tooth sensitivity. So so what is the first thing that you will say? Ah, and then something like sun, right? And then when you're thinking about Talaq-e-Hasan, you can be like you eating a delicious apple and you are giving that reaction. Hasan, wah, like that. Okay. Now let us come to the technical part of what is Talaq-e-Ahsan, as Talaq-e-Hasan and Talaq-e-Biddat. So Talaq-e-Ahsan is the most approved form because, as I told you, Prophet Muhammad called talaq as the most detestable thing, and it is advisable to utter talaq only once, okay, and not thrice. But under the Talaq-e-Hasan, the talaq is uttered during the period of purity, but it will be uttered during the period of iddats as well. Three iddat periods, and in the period of purity. So, for example, if there is a person called as Fatima, so her husband wants to give her talaq. So, since today she has periods, he cannot do it. So, the 8 days after today, she will give talaq. The husband will say talaq, and then the next month also, during the same period itself, the word talaq will be told, and then the third in that period also, the cycle will repeat of telling the word talaq. So this is called as talaq-e-Hasan. Okay, so you should know that this is also not approved in as the most approved form of divorce, because talaq should be uttered only once and not thrice, but it is nevertheless recognized as a form of divorce under the Muslim law. Okay, and the last one is Talaq-e-Biddat. Talaq-e-Biddat is the disapproved form of divorce. Here, the period of tuhur as well as iddat is not followed. It will be in the first iddat period itself. The word talaq, talaq, talaq will be told. Okay, so it is a disapproved form of divorce. And if you have seen the Shaira Bano case, the Shah Bano case, which was actually became a movie, in that, if you have observed, the woman actually says that if a man gives talaq biddat as a way in which he could divorce a woman, then kode padna. So he should be whipped, and then only talaq biddat could be approved. So that was the way in which the Islamic law used talaq biddat. So if I have to tell you, talaq biddat was not recognized as a form of divorce by the Sunnis under the Muslim law. It was something which only the Shias recognized. Okay, and the next one is Talaq-e-Tafwiz. So what is Talaq-e-Tafwiz? Talaq-e-Tafwiz is nothing but delegated talaq. Okay, here the man delegates the power of talaq to the wife. Okay, so this could happen because of a lot of issues such as absence of the husband, absence of the husband, and if the husband takes a second wife and ignores the first wife, the wife could actually include a clause in the tala in the nikah saying that if he takes a second wife, then he'll have to look after the first wife properly. If he's not doing that, the wife could go forward and self divorce herself. That is nothing but talaq-e-tafwiz. But today, if I have to tell you, there is a case law which where it was discussed clearly that if a woman is unilaterally divorcing herself, that is not recognized. So any sort of unilateral talaqs or anything, they have to be elevated before the court, and court should be the one which should sanction talaq. Okay, so that is what is the practice as of now. And then there is something called as khula. Khula is a right of divorce purchased by the woman by paying a price. See, there is something called as dower under the Muslim law. So dower is nothing but prize given to the Muslim wife. You should know that dower is a right given to a Muslim wife. So if I have to tell you a little bit about dower, see, there are two things you should know about dower: prompt dower and deferred dower. So prompt dower is paid at the time of marriage itself, during the time of marriage itself, and deferred dower at the time when divorce happens. So dower is a payment given to the wife. Okay, if a man actually wants to divorce today, dower will act as an impediment upon his unilateral decision to divorce a woman. But you have to know that there is Sunni law which says that the amount of dower that a husband should actually give should not be less than 500 dirhams. Okay, but there is Shia law which says that it could be anyway between 30 to 50 dirhams. So if the amount is calculated today, so how much will it actually be? So 500 dirhams today will be 12,500 rupees. Okay, and then 30 to 50 dirhams will be around 10,000 rupees or something like that. So if you see this much of maintenance, if a woman is given today, that much of maintenance will not be sufficient for her to look after herself as well as her children. So that is when she will be eligible to claim maintenance under section 125 of CRPC of erstwhile CRPC. Now it has become a different provision altogether. Under the present BNS, the BNSS section 144 deals with the powers which are given under the section 125 CRPC. So As a Muslim woman, a woman, if she is not given enough maintenance, she could approach the court under section 144 of BNS. BNSS. Okay, BNSS is nothing but Bharatiya Nagarik Suraksha Sanhita of 2023. So if I have to digress and come back to the lecture which is happening, khula is something where the it is nothing but a right of divorce purchased by the woman, and she is the one who will make a payment and get out of such a relationship. Okay, so here she'll not be paid dower, but she is herself paying a consideration amount, and she is going forward and separating from such a relationship. Okay, and the next one is mubarat. Mubarat is nothing but mutual consent divorce. And the last one is Faskh. Faskh is nothing but dissolution of marriage by Muslim women. So there is an act called as Dissolution of Muslim Marriage Act of 1939. And under that there are various grounds through which a Muslim woman could seek for dissolution of marriage. So I'll be discussing about them in a while. But do know that these are the forms of talaq discussed under the Muslim law. And we will be restricting ourselves only to Talaq-e-Ahsan, Hasan, Biddat, Tafwiz. And then I'll be discussing the difference between talaq and Fashk. Before I go forward and explain about Talaq-e-Ahsan, there are few requisites for a valid talaq. The first one is that the man must be of sound mind. The next is that the person should not utter the word talaq in anger, and the talaq should not be uttered in any forms of intoxication period, like using alcohol, opiates, and things like that. So if talaq is uttered during a period of um, non-sobriety, then such types of divorces are not recognized under the law. If at all, let us suppose that there is a person who has recurrent attacks of insanity, and during the time of insanity he utters the word talaq. So since he is of unsound mind, the talaq will not be recognized under the eyes of law. But if it is uttered in the period of sanity, then the talaq is recognized in the eyes of law. But like I told you, talaq should be a well thought out decision. It should not be something which should be done in haste or in anger or things like that. And then there are other essentials like, for example, in Shias especially, there should be two witnesses who will look into the matter when it comes to utterance of talaq between the couples, then that too male witnesses. And then talaq should be uttered in Arabic language. That is one of the essentials under the Shia law. So this is a general rule, but if at all a man is not able to tell the words in Arabic language, he can nevertheless appoint somebody who knows Arabic language. But if he is not able to afford somebody who can tell the word talaq in Arabic language, that is when he can use his own language to communicate the content. Okay, and then there are few words which have to be used when it comes to utterance of word talaq under the Arabic language. For example, Zawati Fatima Talik, which means that I have divorced Fatima. Okay, so that is what is something which will signify that the person he wants to divorce somebody called as Fatima. Okay, and along with these essentials, there should be two arbiters who will try to act as a bridge between the couples. They will be the ones who will act as mediators when the matter reaches them that the husband wants to divorce. So you should know that when it comes to talaq also there are a lot of restrictions imposed upon a man. So it is not no more unilateral act as which has been as has been um, you know as has been circulated in the social media. So you should know that talaq-e-Ahsan Talaq-e-Hasan and Talaq-e-Biddat also are the three forms of divorce. But Talaq-e-Biddat is a practice which the Muslim law does not even recognize. So we saw in the previous slide, right? Talaq-e-Biddat was something which is never recognized under the Muslim law. It was the most disapproved form of divorce. Now, let us come to the main crux of the matter. So, under Talaq-e-Hasan, what will happen? So, in Talaq-e-Hasan, like I told you, here only one talaq will be told, that too in the period of tuhur and in the first iddat period itself. And then the next iddat period should be maintained, during which the man is given an option to reconcile and join with Fatima. Okay, so that is what is the necessity of having iddat period. Iddat period can signify periods between menstrual cycles, and it can also signify a period which leads to reconcilability among the couples. Okay, so you should know that under Talaq-e-Hasan, the man will be given a chance to reconcile until the third iddat period. Okay, but the word talaq will not be told in each iddat period, that too during the period of tuhur. It is only in the first tuhur that the word talaq will be told under the Talaq-e-Ahsan. Okay, and now you have to know that there is a case law called as Shami Mara versus State of UP 2002. So in this case, it was held that if a woman becomes a victim of triple talaq, then she is somebody who can get maintenance under section 125 of CRPC. Okay, and then here it was held that Talaq-e-Ahsan and Hasan were the most approved form of divorce under the Muslim law. Okay, so this is what was discussed in the matter. In Shaira Banu versus Union of India, Talaq-e-Biddat was struck down as unconstitutional, and it was not something which was endorsed under the Muslim law. And it was also told that Talaq-e-Biddat was not an essential religious practice of the Muslim community. Now let us move on to Talaq-e-Hasan. So in Talaq-e-Hasan, what will happen is, let us suppose there is a person called as Fatima. So here what will happen is, so Fatima husband wants to divorce her. So what is the option available to Fatima's husband? He can utter the first talaq in the period of first tuhur. Okay, and then next in the next iddat period, again during the period of tuhur, he has to utter the second talaq. And last but not the least, in the last iddat period, again one more talaq in the period of tuhur. But here you have to know that after the utterance of the talaq in the first tuhur, the husband can nevertheless take back and say that I want to reconcile with Fatima. Reconcile with Fatima. Okay, and that could happen even during the period, third iddat period as well. See, in the second iddat period also he ended up saying talaq. But here what will happen is, the divorce will be revocable until then. But the talaq will become irrevocable if the man does not reconcile and say talaq in the third iddat period and in the period of third thur. Okay, so yeah, you are understanding, right? Yeah. So now we'll discuss one of the important case laws which talk about Talaq-e-Hasan. So there is a recent case law which is discussed before the Supreme Court, which was Benazir Hina versus Union of India. So here it was regarding whether even Talaq-e Talaq-e-Hasan is also the right way to divorce. Why this was discussed was that, as I told you, Prophet Muhammad himself had told talaq should be the last resort. Okay, and talaq is something which should be uttered only once because it is a detestable thing. So, what is the point of repeating the words thrice? So that is why the validity of Talaq-e-Hasan was raised before the court. So we have to see how the matter will move before the court. But you should know that it is a violative of Article 14, Article 21, and a lot of other articles of the Indian Constitution. Constitution. In the comment sections, do let me know what are the things that you have found out in the matter which I have left out. Now let us talk about Talaq-e-Biddat. Talaq-e-Biddat has been struck down as unconstitutional in Shaira Bano versus Union of India case, which happened in the year 2017. So you should know that Talaq-e-Biddat has been given the most disapproved form of divorce status under the Muslim law, and Talaq-e-Biddat is not recognized by the Sunnis. Sunnis don't recognize it as a form of divorce itself. If you look into the judgments, be it Shaira Bano or Shah Bano, they never get into the details as to what did the Shia law say, what did the Sunni law say, nothing like that. So we could actually constructively criticize these judgments because the judgments could answer all the questions related to Talaq-e-Biddat, but that has not happened in the judgments. So do let me know in the comments what are the other criterias that the court could have looked into in the Shaira Bano versus Union of India case as well as the Shah Bano case. Alright. I will be doing about Shaira Bano and Shah Bano case. I'll be giving an analysis of that. So stay tuned until then. Anyway, in Talaq-e-Biddat, what will happen is uh, that the person will not wait for tuhur, neither iddat, and in the first instance itself, he will say talaq, talaq, talaq. So it is the most disapproved form of giving talaq. But there were instances where a woman was given talaq using Skype. So it became a unilateral act in the hands of the husbands. We all saw the essentials of talaq, right? So such if today a woman is given talaq using Skype, then she can question the validity of the talaq in the eyes of the law itself. So you have to know that there are a lot of safeguards given to the woman. So if a man today utters talaq, so she can question that talaq was not proper at all, and she can say that she is entitled to maintenance irrespective of whether the matter will lead to divorce between the couple or not. Now let us discuss about Talaq-e-Tafwiz. Talaq-e-Tafwiz is nothing but the power of talaq delegated to the wife. So in this, what will happen is there are certain circumstances. For example, if the man goes forward and commits apostasy, and if the man ends up getting missed for a period of more than 7 years, and then if the man turns out to be an impotent, and if the man takes a second wife and ignores the first wife, and the woman in the nikhanama can put in a condition saying that the person she's getting married to will be married to only her. So such conditions could actually be put in the nikhanama. So if that is not being adhered by the man and he is taking a second wife, the woman can go and file a case before the court saying that, well, since I had put this condition, why is it that the condition is not being fulfilled? Although you have to know that the Muslim law does not endorse polygamy. It says that it is an exception rather than a rule. So in exceptional circumstances, a Muslim man can have four wives. But it is not a necessity or it is not a mandatory rule that the Muslims should follow. Also, in a lot of circumstances, what has been led by the court is that in case a man takes a second wife, the husband should obtain the permission from the court. Otherwise, the marriage with the second wife is not recognized in the eyes of the law. Faskh is nothing but a petition which a Muslim wife could use for going forward with dissolution of marriage. So there are various grounds enumerated under the Section 2 of Dissolution of Muslim Marriage Act 1939, in which some are whereabouts of husband not known, then neglect or failure to provide maintenance for a span of 2 years without reasonable cause, imprisonment for 7 years or more, impotency, virulent venereal diseases, and there is one more option given to a woman, that is khayar ul buluk, which is nothing but option of puberty. So under the Muslim law, before the girl turns 15 years of age, she has the option of repudiating the marriage, and she could actually avail and say that at the time of marriage she was a minor and that she had not given the consent for the marriage, and then she can also say that the consent was obtained due to fraud or things like that. And then she could also show that there was no consummation of marriage. In a lot of cases, it has been held that option of puberty is still available for a woman even if she consummates the marriage. She will be entitled to get maintenance from the husband. And there are other grounds such as cruelty, then habitual offense of uh, cruelty, and then abuse. Then if he stays with women of ill repute, and there are other grounds as well. So you can see them in the slide. Now let us chalk out the difference between talaq and fask. The first difference is that talaq is a unilateral act in the hands of the husband, but fask is a device given to a woman due to the intervention of court and also under the provision of Dissolution of Muslim Marriage Act 1939. Talaq has different modes such as Talaq-e-Ahsan, Hasan, and Biddat, whereas fask has certain exclusive grounds which are given to a woman. Here, the courts are intervened, and it is a court process through which the dissolution of marriage happens. But under talaq, it is a unilateral act, and it does not include the intervention of court. And here you have to understand that when it comes to right to dower, can dower be given even though a woman is going forward and becoming a victim of a unilateral act of talaq or not? So there have been instances where under the triple talaq, a woman was not given maintenance rights. That was what has happened. What had happened in Shah Banu's case. So the woman was denied maintenance under Section 125 CRPC because she had become a victim of triple talaq, and also she asked for 500 rupees as the maintenance amount at that time itself. So the court actually held that even a woman who is a victim of triple talaq, even she is entitled to get maintenance. So now if we are talking about dower, dower is nothing but consideration. Here you have to know that under the Muslim law, during the time of marriage, if the man does not pay any consideration, all he could do was teach the woman Quran. Okay, so you should know that the Muslim law did not did not provide for materialistic rods, but also rods like these. So the right of dower could be something which could be waived off. At the same time, it could be something which could be included in the nikhanama itself. The nikhanama itself, a woman can be shown what is the dower that she will be entitled to get at the time of marriage, and as well as during the time when talaq is given. And under Faskh, what will happen is the right to dower will not be affected at all. there is a provision under Dissolution of Muslim Marriage Act which will say that right to dower will not be affected under the provision. Here you have to know that under Faskh, it could be either dower or maintenance, and it cannot be both. But if dower today is around 12,500 rupees, what maintenance can she actually do if she has more than two children or three children, like that? So if the number of dependents on a woman are more, and provided she proves that she is living a life of destitution, then she'll be entitled to get maintenance as well. So here you have to know that under the present BNSS provision, the woman should prove that she had been neglected, that without reasonable cause, and then she was living a life of destitution, like that. So she'll have to prove a lot of things. Here the proof is not of reasonable doubt but preponderance of probabilities. Thus, I would like to conclude by stating that talaq is a unilateral act in the hands of the husband, whereas faskh is something which is a device in the hands of the wife, which could be sanctioned only through the court's intervention. And under faskh, there is exclusivity associated with it. Only the women can go forward and claim dissolution of marriage under the section 2. And here you have to know that, as I told you earlier, if the right to dower or the dower offered is not enough, that is then the woman can claim maintenance under section 125 CRPC or section 144 of BNSS. Thank you for listening to my lecture, and do let me know in the comments what are the doubts that you get while listening to my lecture. Thank you once again, and stay tuned. I'll be updating a lot of other contents.